Well, welcome to Checks and Balances in the Constitution. Hopefully have some fun today. It's interesting, historically, the Constitution had quite an interesting historical background. The founders had just come from a very, very strong centralized government, hadn't they? Britain was a very strong and very powerful centralized government. And so they said, what we need to do is we need to decentralize and not have a strong central government. So what we brought in after winning the War for Independence was the Articles of Confederation. The challenge of the Articles of Confederation, though, is that it offered too weak of a central government. And so they found themselves with a dilemma, swinging the pendulum from here to there, strong government or not a strong central government. And what they came up with as a solution was the Constitution, which gave more power to the central government than the Articles of Confederation had given, but it checked and balanced that power so that the central government couldn't grow bigger and stronger because of those checks and balances. We're going to explore those today. Okay? So we're going to hit some definitions. We always start out with some definitions to get a baseline for where we're at. The first definition I want to hit is sovereignty. Sovereignty is kind of a big word, but it's a really simple concept. It's the idea, it's the highest level of decision-making authority. It's a state of supreme rule, also self-rule. One way I like to say the sovereignty is the buck stops here, right? I am sovereign. I make decisions for myself. We all know there's one ultimate sovereign in the world. That's God. But sovereignty is the idea of self-rule. You're in charge of yourself, okay? That's what sovereign means. Secondly, we're going to discuss this word jurisdiction. Jurisdiction is also a big word, but it's very simple. The extent or range of power or authority. Okay, so you have a sheriff who's in this county who pulls someone over. Can they do that? Yeah, because it's in their jurisdiction. But can a sheriff from another county pull me over? No, it's not in their jurisdiction. It's not the range of their authority, okay? Thirdly, a state. A state's interesting because you look at the 1828 Webster's Dictionary and it calls a state an independent country, a geographic and people-separated area distinct from other nations or lands. We tend to think of a state as kind of a subordinate unit to a nation, right? That's we're states and we're subordinate to the national government. And you look at it, what he says, and what the Founding Fathers understood the word state to mean is an independent country. Kind of interesting. Now, another definition is federal. Okay, federal is derived, this is according to 1828 Webster's Dictionary as well, it's derived from an agreement or covenant between parties, particularly between nations. So we have a federal government, which is essentially a unifying of sovereign nations that come together under a federal government and form the United States of America. But you notice in the Declaration of Independence, it's kind of interesting. United is a small little word, and then states is this huge word, because it's all about the states. Be unified for certain reasons, but these United States, right? And federalism, that's an interesting concept and a take on this word federal. Federalism is based on the idea of different levels of government. Okay, we know there's local government and there's county, there's state, and then there's federal government. Those are different levels. That's what federalism is, at different levels of government. And it's really based on this concept, the governing at the lowest appropriate level. Never, ever give to a higher level of government that which you can do yourself at a lower level. Don't move it up the chain. Keep it as local as possible. That's the principle of federalism. The principle of federalism is found all through the Constitution, and it's critical. It's critical because what is it doing? It's decentralizing government, and that's the essence of the freedom. Less government, more freedom. Okay? So now we're going to move on. We got hopefully a foundational idea of some of the definitions. We're going to move on to this slide that I have that I think is interesting because many people would say, well, that's it. That's checks and balances. We're all done. There's nothing else to talk about. Okay, so there's three different branches of government, right? Legislative, which makes the law, the executive, which carries out the law, and the judicial, which judges the law. We all know that, right? Pretty simple stuff. And we're all taught, essentially, at least what I was taught, is each one of these has a check and balance power on the other. Ends up being 6 different powers. Let's discuss those a little bit. The executive has the power over the legislative. When the legislative makes the law, when Congress makes the law, the executive, the president, can what? He can veto that law, can't he? Okay? Now, that's one check they have on the legislative power. The check the executive has on judicial power is they're in charge of appointing the judges. Okay? So you got your executive checks and balances there. What about the legislative? Legislative can check the executive. When the executive chooses to veto a law, what can the legislative do? They can override that veto with a 2/3 majority vote. Okay? And the legislative has a check on the judicial power because the Senate has to concur on Supreme Court appointments. Okay, so the executive appoints judges, but those judges have to be agreed upon by 2/3 of the Senate to say, yeah, we're going to go ahead and allow that person to be put in as a federal judge. Okay, now we look at the judicial, their check and balance. The one that people know about here is judicial checks the legislative. When the legislative makes the law, the judicial can rule that law to be unconstitutional. Okay, and then also one that's less known, but still there, judicial checks the executive by issuing court orders and telling the executive to carry out this order from the court. Now, like I said, most people look at that slide and say, we're done. That's it, isn't it? And is there anything else to talk about? It's interesting that when we look at the slide, how much we're indoctrinated to understand that that's all of checks and balances. And when you look at it, where are those checks and balances? Those are all at the federal level. They're all at the federal level. And so we tend to think the only check and balance that exists is at the federal level. We're going to explore this a little bit more and realize there's so much more to checks and balances than just what exists there. And these are very simplistic versions. There's many other checks and balances that exist that we're going to look at. So we're going to start out with a really good quote by James Madison. Okay, he says, "In the compound Republic of America, the power surrendered by the people is first divided between two distinct governments." I like this quote for a lot of different reasons, but firstly because it says the power is surrendered by the people. Remember in the first presentation we did, the power is in the people, and the people surrender that power to the government to act on their behalf as their agent. So I think he's right on. I know he's right on. He's the father of the Constitution. Very, very good point that the people surrender that power. And then the key word I think here that's interesting is this word divided. Okay, that power is divided between two distinct governments. What are the two distinct governments he's talking about? The federal and the state. The power is divided between the federal and the state. And then he goes on to say this, "And then the portion allotted to each subdivided among distinct and separate departments." And the word I like to point out there is this idea of separate, the separation of powers. Okay, so within each different level of government, there is a legislative, executive, and judicial branch. At the federal government, there's legislative, executive, judicial. At the state, legislative, executive, judicial. At the county, the same thing. And so you see, as he says, he goes on to point out, "Hence a double security arises to the rights of the people. The different governments will control each other at the same time that each will be controlled by itself." Isn't that beautiful? So you look at that in comparison to the previous slide and you say, oh yeah, checks and balances aren't just horizontal. They're not just the separation of powers. They're also the division of powers, the check of one government over another. And that's something we've lost. It's a beautiful part of our Constitution. It's something we've definitely gotten away from. We just think of the separation of powers as, well, at the federal level, they check each other, and it's all horizontal. The division of powers is the beautiful thing. He goes on to say, "Each state in ratifying the Constitution is considered as a sovereign body, independent of all others and only to be bound by its own voluntary act. In this relation, then, the new Constitution will be a federal and not a national Constitution." And those two words are italicized there, national and federal. What's the difference? In a national government, like we talked about earlier, states are subservient, aren't they? They do what the nation tells them to do. But in a federal government, you have a federation of independent, what some people call mini nations, right? We come together and say, oh, yeah, we're federalizing. We're not subservient. We don't just do whatever they tell us to do. We're coming together to form this government. When the colonies, the states got together, they said, look, we're independent. We're sovereign. We're fine. We don't need any other government. But there are a few things we'd like the government to do. We need a centralized government to do. And so we're going to go ahead and outline what those things are. We're going to write a constitution and give them certain enumerated listed powers. Here's what you can do. And please do those for us, but don't do any other ones. So they get together. So all, as a whole, when you look at it, the United States together, when they operate and do things together, those are the powers that we've given to the federal government to do the external things, not the internal things. The internal things are for the states. The external things are for the United States. There are a few minor exceptions, and guess what? Those exceptions are listed in the Constitution. It says very clearly, here's what the federal government can do when it has to do with internal affairs. But most of those affairs of the United States, of the federal government, are external issues. Okay? Thomas Jefferson put it this way, in defining this, remember this idea of federalism, right? The idea that there's different levels of government. "Let the federal government be entrusted with the defense of the nation and its foreign and federal relations. The state governments with the civil rights, the laws, police, and administration of what concerns the states generally. The counties with the local concerns of the counties, and each ward direct the interests within itself." That quote just screams federalism, doesn't it? Every level has its own jurisdiction. They take care of their own selves, and they all have different levels. Not that anyone's above any, they're all just different. Okay? So in other words, looking back at this map, you look at Wyoming, all the things that concern Wyoming internally are issues of the state. The state takes care of those. Our challenge today is almost all of our issues that are internal are dealt with and controlled by our central government from DC. That's a problem. That's a major problem because that's not their role. They're crossing jurisdictional lines and they're creating all kinds of chaos and havoc. If they let us be free, which we are, we're sovereign, and take care of our own internal issues, we won't have all the many problems we have today, or many of the problems we have today. So Jefferson asks the question here, what's destroyed the liberty and the rights of man in every government which has ever existed under the sun? The generalizing and concentrating all cares and power into one body. Okay? That's what's happened. Throughout history, historical fact, what's destroyed freedom is centralizing of power. He says also, when all government, domestic and foreign, in little as in great things, shall be drawn to Washington as the center of all power, it'll render powerless the checks provided of one government on another. There we have that again, right? One government on another. And will become as venal and as oppressive as the government from which we separated. Okay, so why does this happen? This is prophetic, isn't it? You look at these founding fathers and they weren't just guessing. Once again, what they wrote was based on principles in human nature. They understood, they saw, they were historians. That destruction of freedom has always come with centralized government, okay? And it's going to render powerless the checks of one government over another. So they were able to see and say, look, this is going to happen. DC is going to take over. Watch out. Interesting, the prophetic words that they had, because that's what's happening today, isn't it? So where does this misunderstanding come from? Where is it that we have this idea? Because I don't know how you guys are, but I've always grown up thinking we had DC's in charge and they tell us what to do, right? That's kind of how it is. That's America, and we're proud of that. Where does that come from? I think, in my opinion, it comes a lot from the misinterpretation of Article 6 in the Constitution. Article 6, Clause 2 says this, the Constitution and the laws that shall be made in pursuance thereof shall be the supreme law of the land. This is commonly known as the Supremacy Clause. We talked about this in our first presentation, in Power in the Constitution. Supremacy Clause. Now, a lot of people read this briefly and just say, well, it says right there, federal laws trump state laws. Is that what it says, though? It doesn't say that. It says the Constitution is the supreme law of the land. It doesn't say the federal government. And what if there's a federal law that contradicts a state law? Most people say right away, well, the federal law trumps the state law. It's not an issue of federal or state, it's an issue of jurisdiction. Does the federal have the right and the authority to act in that area, or do they not? If they don't just trump the state just because they're federal. Because the federal government isn't a higher level government, it's a different level of government. And we tend to think that supremacy, we tie that supremacy clause into supremacy of the federal government over the state government. That's simply not true. It's in the Constitution, because the Constitution doesn't say the federal government's in charge, it says the Constitution is in charge. Okay? Now moving on a little bit more to the end of Article 6 here, it says, anything in the Constitution or laws of any state to the contrary, notwithstanding. So it's easy when you first look at that and say, oh wait, it says right there though, anything in state constitutions or state laws that's contrary to this, federal law trumps it. That's what's easy to think is what it's saying. But it's not saying that. It's saying we're establishing clear lines of federalism, clear lines of authority. And any crossing over, that's what's unconstitutional. Not the federal law can do whatever they want to. If the state ever tries to contradict it, then the federal wins. That's not what it's saying, is it? Okay? I may have done a bad job explaining that, but Madison does a great job explaining it. Here's what he says. This is a gem. He says in a national government, remember, we're not a national government, are we? Okay, we're a federal government. In a national government, all local authorities are subordinate to the supreme and may be controlled, directed, or abolished by it at pleasure. In a national government, you do whatever they tell you to do. But he goes on to say, in a federal government, which is what we are, the local or municipal authorities form distinct and independent portions of the supremacy, no more subject within their respective spheres to the general authority than the general authority is subject to them within its own sphere. Isn't that cool? That's what he's saying, right? You understand? There's that jurisdiction that's set up, and we're no more subject to the federal government than the federal government's subject to us. It's a matter of jurisdiction. It's a matter of delineating what and who is in charge. And that's the principle of federalism. The Constitution itself, when it governs, it itself in the 10th Amendment, it regulates and restricts the federal government's abilities and powers, doesn't it? We talked about this earlier as well. It says the powers that are not delegated to the United States by the Constitution, nor prohibited by it to the states, those powers are reserved to the states respectively or to the people. Okay? So when the Supremacy Clause says the Constitution is the supreme law of the land, the Constitution itself puts restrictions on the federal government, on the United States, the federal government. and what they can and can't do. Because, quite simply, if the power is not given, it is not there, and it's reserved for the states or the people. Now, an interesting point that I like to make here, I've had a lot of people tell me, in constitutional lawyers who say, well, there's this thing called plenary power, absolute power, and the states have absolute power. Now, does that sit well with you? That doesn't sit well with me. People have absolute power, and they choose to delegate to the state certain powers, and they choose to delegate through their state to the federal government certain powers. But the ultimate power lies in the people, right? Remember the Declaration, deriving their just powers in the consent of the governed? Only the governed, who actually have rights given to them from God, can delegate power and authority to higher levels of government to act as their agent, to act on their behalf, to do things they could do on their own, but they allowed them to do for them. So a lot of people misconstrue, in my opinion, the 10th Amendment to say, well, yeah, it shows that the ultimate power is in the states. It's not in the states, it's in the people. And they're the ones that choose who to give it to. Okay? Now, there's an interesting quote here by James Madison. This is, I don't know, I get really excited about it. In fact, I had like 15 of his quotes. I had to cut them all down because there's just too many. But this quote I really enjoy. He says, the interest of the man must be connected with the constitutional rights of the place. He's starting to talk about how do you form these checks and balances? How do you put them together in the Constitution? But what you have to do is you have to make sure the place or the position coincides with the natural inclination of human nature, of people, how they are. Don't go off this altruistic idea that, oh, they'll always want what's best for people. Let's just look at real human nature and tie it together. So his quote goes on to say, it may be reflection on human nature that such devices should be necessary to control the abuses of government. But what's government itself but the greatest of all reflections on human nature? Isn't that what government is? Okay? It's a reflection on human nature. So why don't we build that in there? Why don't we build a natural check and balance? That if I have the power to make a law, I'm going to naturally say, whoa, you can't take that power. That's my power. Because that's how I am as a human too. I want to guard my power. It's mine. I'm not going to let someone else have it. Okay? He says, if men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. Okay, does that get you guys excited? It gets me excited. Those quotes like that are awesome. And you realize these are founding fathers. These guys got it. This is incredibly godly and principle-based constitution they put together, understanding the true nature of man and principles of freedom. That just gets me excited. Okay, so now we're going to get into the Constitution a little bit. This slide is called Constitutional Checks on Power, and I've gone through, and it's kind of a messy slide. There's a lot to it. What we're going to do is we're going to build the ladder on the left-hand side of the interaction between legislative and executive. And on the right-hand side, we're going to build a ladder between the legislative and the judicial. And what I'm going to do is get little quotes and little references to the side of where the constitutional reference is for these powers. For example, okay, the first one here says Congress passes a law. Well, where does Congress have the authority to pass a law? Article 1, Section 1, Clause 1. All legislative powers herein granted shall be vested in a Congress of the United States. Okay, as an example. So now we're going to build this ladder. Now, when Congress passes a law, and on the left-hand side, we're talking about interaction between the president. We've already talked about this before. What can the president do? If Congress passes a law, the president can veto that law. Okay? And he can veto it, and the reason he can is because Article 1, Section 7, Clause 3 states that he can. It specifically enumerates that power. And when the president vetoes a law, does Congress have any recourse on that? Yeah, Congress can override the veto with a 2/3 majority vote. And that's also found in Article 1, Section 7, Clause 3. Okay, so you have Congress, and then you have the president vetoing, and then you have Congress overriding his veto. Now, does the president have any recourse at this point? Once a law, most people shake their head and say no. But you look at it, it's really interesting. Even though you don't like this, and I don't like it either, it doesn't settle well with me. It took me a while to really get my mind around this. The president, what he can do is he can choose, he or she can refuse to enforce the law. Now, that's in violation of Article 2, Section 3, Clause 1. He's supposed to faithfully execute the laws of the Union. But as I've studied the founders, I've really realized the thing they feared most and wanted to make sure is that those who made the law couldn't execute the law. They wanted to separate those powers, this whole idea of checks and balances. And so a natural check and balance is he who makes the law is different than he who executes the law. Naturally, the person who executes it can say, I'm not going to execute that law. It's a natural check and balance. And we say, wait a second. But that's happening today, isn't it? Think about our borders. Think about Defense of Marriage Act. Is the executive choosing not to enforce? Yes. Is he choosing not to enforce in violation of the Constitution? Yes. But it's a natural check and balance that does occur. Okay? We're going to leave that there because it's probably got us a little bit frustrated. We're going to go to the next side. Okay? On the right-hand side, we're going to build this ladder again. Congress passes a law, Article 1, Section 1, Clause 1. What recourse does judicial branch have on Congress passing a law? Well, they can rule the law to be unconstitutional. Okay, and that's according to Article 3, Section 2, Clause 1. Now, when the courts rule a law that Congress passes to be unconstitutional, does Congress have any recourse on the courts? Most people would say no. No, it's a done deal. They interpret what the law said and it's done. But it's really interesting that Congress most definitely does. Congress can limit the appellate jurisdiction of the courts and or dissolve and reorganize lower courts. Now, a lot of people say, no, wait a second. Are you telling me that the Supreme Court makes a judgment, issues an opinion and says, we're interpreting the Constitution this way, and the Congress can actually override that? Yeah, they can override that. How do they override it? Well, through Article 3, Section 2, Clause 2, they can limit the appellate jurisdiction. What's that mean? Appellate, kind of a big word. Appellate simply means the appeals process. Okay? So someone has a case, they bring it before the judge, the jury, they have this a result that they don't like, so they appeal it to the Supreme Court, all the way to the Supreme Court. And the Supreme Court says, here's what we rule. Okay? And Congress says, well, we don't like that ruling. We think it's a bad opinion. So they can say, thanks for your opinion. You'll no longer be ruling on those issues because we're going to limit the appellate jurisdiction. You will no longer hear issues regarding that topic. For instance, for example, abortion. Roe versus Wade. When that came through, 80% of America was against abortion, but somehow the Supreme Court found somewhere in the Constitution where, oh no, a woman has a right to kill her child. Never mind the rights of the child that live. A woman has a right to kill her child. And the people are saying, whoa, we don't like that. But we all go, well, it's established law. The Supreme Court made that decision. We have to follow it. What should have happened is Congress should have said, you're wrong. Thanks for your opinion. That's all it is, an opinion. And we no longer let you rule on any abortion cases because you got that wrong. We're not going to let you perpetuate that misinterpretation of the Constitution. Why would Congress be able to step in and do that? Well, because Congress represents us. That's why. And we're in charge. Okay? We're not run by some group of Supreme Court justices. Now, the other thing is Article 1, Section 8, Clause 9 says that Congress can dissolve and reorganize lower courts. So we have the Ninth Circuit District Court of Appeals, right? In San Francisco, the liberal court that always gets it wrong, or at least according to conservatives and Christians, etc. What can happen? Congress can say, you know what, you've done such a bad job, you're out of a job. You're done. They can do that. Why? Because we, the people, are in charge. Okay? So Congress can trump the Supreme Court. Now, when we're building this ladder here, going up one more step, does the judicial have any recourse over Congress? They do. In this situation, Supreme Court of the United States maintains original jurisdiction and judicial power. Okay, according to Article 3, Section 2, Clause 1, it's not that the Congress can never limit the original jurisdiction of the Supreme Court. They can only limit the appeals cases that come through the appeals process. Okay, but the original jurisdiction they can't touch. The original jurisdiction is for the Supreme Court to decide on those federal controversies, those federal cases that happen between nations, etc. Okay, now, and they still have the judicial power. The Supreme Court can still judge laws that are put out by Congress to be unconstitutional. They can't say you can no longer judge. They still have the ability to judge laws to be unconstitutional. Okay, so we built these two ladders, right? On the left-hand side, it kind of bugs because the president, eventually, he's the one who's in charge and over Congress. On the right-hand side, you have the Supreme Court, who's trumps Congress. Does that sit well with us? No, we're Americans. We're in charge. What's going on here? Well, the question then becomes, does anyone have any power over, does Congress have power over the president or over the Supreme Court? Yeah, they do. They can impeach them, right? Okay. So Congress, with a 2/3 vote, can impeach the president, and with a 2/3 vote, they can impeach members of the Supreme Court or the other federal court justices. Okay, that's according to Article 1, Section 2, Clause 5, and Article 1, Section 3, Clause 6. It's a little known fact that not a lot of people know about, but Congress can actually impeach members of its own Congress with a 2/3 vote as well. Okay, so let's say they wanted to do that. They can impeach Congress with the authority in Article 1, Section 5, Clause 2. Now, let's say that doesn't happen. Let's say Congress is in charge here. They are, aren't they? They're in charge. They trump, and we like that. But is anyone in charge of Congress? We are, aren't we? The people are in charge of Congress. We, the people, can vote members out of Congress. And obviously, that's according to Article 1, Section 2, Clause 2, and Article 1, Section 3, Clause 1, which now has been superseded by the 17th Amendment, talking about election of senators. Okay? So, we, the people, are in charge, and we're on top, aren't we? How does that sit with us? That's Americanism, isn't it? We, the people, are in charge. So we've talked about all these check and balance powers all the way up these ladders. I like to call the power that the people have the checkmate power. Okay, so you talk about check, but the people have the checkmate power in the end. Which brings us to an awesome quote by Abraham Lincoln. He says, "We, the people, are the rightful masters of both Congress and the courts, not to overthrow the Constitution, but to overthrow the men who pervert the Constitution." Isn't that a good quote? Isn't that what it's saying? It's our job, and we, the people, are in charge. Okay? Now, if we, the people, are in charge, then there's some duties incumbent upon us, aren't there? We're free, but with that freedom comes some duties. George Washington makes this point. He says, "The primary object should be the education of our youth," and I would add ourselves as well, "in the science of government. In a republic, what species of knowledge can be equally important?" We need to understand true principles of freedom and true principles of republicanism. If we don't, we deserve every bit of bad government we get, don't we? Okay? He also makes the second point that I think is the second incredibly important pillar. Human rights can only be assured among a virtuous people. The general government can never be in danger of degenerating into a monarchy, an oligarchy, an aristocracy, or any despotic or oppressive form, so long as there is any virtue in the body of the people. So I think he hits the nail right on the head. 2 points. First, to love and know the principles of the Constitution. Secondly, to love and know God and act that way. Act virtuously. You have those two things, and then it's good that the government's on the shoulders of we the people. If those two things aren't there, then it starts to crumble, doesn't it? Because our moral fabric and our freedom fabric is being torn apart, and that's what we see in the country today. Because we the people are in charge, and we the people in general are apathetic, are not moral, or not virtuous. That's why I have the struggles we have today. Okay? So now we're going to get into some of the actual words of the Constitution, okay? This is where we get into the fun part of finding out what it says and looking at it. And hopefully it'll be just as fun as what we've hit before and go, whoa, I didn't realize that. This is new stuff, and it's exciting because the Constitution has those answers. Okay, the first thing I wanted to point out is a trial by jury, okay? If we the people are in charge, what's the trial by jury say? The Sixth Amendment says, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury." And the very next amendment, Seventh Amendment, says, "In suits at common law, the right of the trial by jury shall be preserved." So, in these trials, who ultimately decides our guilt and our innocence? The jury. Not the judge, not the system, not the bureaucracy, the jury. Now complete the sentence for me. A jury of their peers, right? That's what we all hear and understand. Why are peers? Why are they the ones who are in charge of our guilt or innocence? Because that's where freedom's found. It's not found in the bureaucracy. It's not found in the system. It's found in the people. Common sense people who think like we do, live like we do, and say, I think they're guilty. I think they're innocent. And that's where the power lies. It's in the people. So trial by jury offers that as well, doesn't it? Okay? Now, moving on to Article 3, Section 2, Clause 2. In all of the cases before mentioned, the Supreme Court shall have appellate jurisdiction both as to law and fact. Now, what if someone goes to a trial, isn't happy with the verdict? What opportunity do they have? They can appeal it, can't they? They can appeal it through the process till eventually it ends at the Supreme Court. And that Supreme Court has that jurisdiction, like it says here, to rule on any of the appellate. Remember how we talked about appellate meaning appeals? They rule, and they're the ultimate authority of the appellate jurisdiction. Okay? They can do that. Now, it's interesting, when the Supreme Court, when they issue a decision, what are those decisions called? The decisions, even the Supreme Court issues them, they're called opinions. That's all they are. And many, many times it's a 5-4 split decision. Okay? The majority opinion is issued by those who are in the 5 court, right? And the minority opinion is issued. And I've done a lot of research on this, and you can take this to the bank, okay? This is very technical terms here. What happens is, when there's a 5-4 split decision, it means there are 5 smart justices and there are 4 dumb ones. Is that what it means? That's not what it means. Oh, no. What it means is there's 5 that are right and there's 4 that are wrong. It doesn't mean that either, does it? What it really means is there's 5 who won and there's 4 who lost. That's what a 5-4 split decision means. And what did those 5 win? They won a contest of opinions. Now, it's interesting because when that opinion is issued, does that mean that, oh, well, now they've reestablished what the Constitution means? It is now the law. In the past and in the future, they've reestablished. The Supreme Court has now interpreted the Constitution to mean this thing. From here on, forever. That's what we tend to think, isn't it? But that's not what the Constitution says. Let's look at what the Constitution does say. Because in Article 3, Section 2, Clauses 1 and 2, It very clearly states the judicial power shall extend. Okay, this is a quote from the Constitution. In other words, the jurisdiction of the Supreme Court shall extend to, what's it say? All cases. All cases. All cases, controversies, controversies, controversies. All cases and in all cases. So this opinion that's been issued, that's changed and misinterpreted or whatever it may do, it applies to the case, just to the case. So Roe versus Wade, established law that we all have to abide by now? No, an opinion that was issued in the case of Roe versus Wade. And yet, due to the apathy and ignorance of the American people, we just say, well, doesn't the Supreme Court tell us what it says? And if they do, then we just have to do what they tell us. Understanding what the Constitution says instead of what the media or schools push down your throat. Understand what the Constitution says, though, helps us understand, oh, wait, that only applies to the case. And you can see why it should only apply to the case, because it's just an opinion, and in some cases it's razor sharp, it's 5-4. That opinion is not going to change the rest of the course of history. It's just going to change and be the official law in that case, that controversy. So piggybacking on that idea, you have elitists, you have progressive, you have people who are wanting to be in charge and have a bigger central government. Why would they not push that idea? It's a great idea to push that, because what do you need? You only need to control 9 Supreme Court justices. You don't have to control the people. You just have to control the justices. If you can control them, you can write law, rewrite law, reinterpret law. It's so much easier to control 9 people than it is 300 million people, isn't it? Now, it's wrong. It's absurd. It's not true. And the reason we know it's not true is because the Constitution says, it says it very clearly in Article 3, Section 2, Clauses 1 and 2. Their jurisdiction is just to the case or the controversy. Now, where did all these shenanigans start? Where did the Supreme Court start saying, oh, we're in charge of deciding what the law says? Where did that start? Unfortunately, it started way back in 1803, right after the Constitution was ratified. Okay, in Marbury versus Madison, Chief Justice John Marshall said this: "It's emphatically the province of the judiciary to say what the law is." Now, it is the province of the judiciary to say what the law is. They must interpret that Constitution and apply the law or not apply the law, but only in the case. People take Marbury versus Madison and say judicial supremacy reigns. The judicial, they decide, the Supreme Court decides what the Constitution means. No, they decide what it means in that case, and if they're wrong, what are the consequences? Well, it can ultimately lead to impeachment. The other consequences is they can say, well, we're no longer going to let you hear appeal cases on that because you misunderstand, you misrepresent, misinterpret the Constitution. Okay? So they can do that, but it's not all-encompassing. It's not what we have all understood to believe, that the judicial, they're supreme. They say whatever they say is what the Constitution is. That is not true. Okay? Now, there's a man named William Blackstone. He was an incredible lawyer in Great Britain. He was one of the mentors of the founders. Okay? He said this, very, very clear. Whenever a question arises between the society at large and any magistrate vested with powers originally delegated by that society, when there's a conflict between what the people think and what the people they elected think, okay, so we have a decision to make here. It's like when the Supreme Court issues a bad ruling or something we don't like. He says, it must be decided by the voice of the society itself. There is not upon earth any other tribunal to resort to. Because who's in charge of the Constitution? Is it 9 Supreme Court justices, or is it we, the people? It's we, the people, isn't it? So when there's a discrepancy between what they say and what we think, who must decide? We, the people. And that coincides with Article 5 of the Constitution. Article 5 of the Constitution says very clearly the only way to change the Constitution is through the amendment process. 2/3 of the House, who are elected directly by the people, 2/3 of the Senate, and then 3/4 of the conventions of the states, so that the people are integral. They're the ones who decide when you change the Constitution. Judges can't change it. Only the people can change it. And that coincides with what William Blackstone's talking about. The people are in charge. Society itself must decide. You can't change what the Constitution means simply by a Supreme Court ruling. They may misinterpret it, but luckily the boundaries are the case. It doesn't go outside that case. And luckily there's also consequences. Congress will say, fine, we're not going to let you hear any more of those cases, or, it's so bad we're going to impeach you. So there's consequences of that. It's not what we hear today. Once they make the decision, it's over. Great, now what? Okay? So moving on here, Article 3, Section 2, Clause 2, we've already read this. Okay, we're going to read it again and see this big word that comes out. In all of the cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact. What's the big word that pops out? Should be this word cases. Okay? In all of the cases, their jurisdiction only applies to the case. So a ton of people, me included, so I'm not putting anyone down, we tend to think somehow a law, when it comes out of Congress and off the president's desk, somehow it kind of goes through the Supreme Court and they have to say, oh yeah, we like it or we don't like it. That's not what happens. The only time the Supreme Court rules on a law is when that law is part of a case or a controversy and they get to rule on whether to apply that law or not. Okay? It's only when it comes to them through the case. Very clearly, their only jurisdiction is when the case brings that up. And then they can apply it or not apply it in that specific case, based on the specific circumstances and facts of that case. Now, here's what we talked about before. This is something that probably was like, whoa, this is way different. I hadn't thought about it. We're going to hit a little more deeply here. This idea, the end of Article 3, Section 2, Clause 2, with such exceptions and under such regulations as the Congress shall make. Okay? So the Supreme Court has appellate jurisdiction, but it's regulated and there can be exceptions made by who? By Congress. Congress can say, nope, you're not going to hear those cases anymore because you're wrong. You issued a wrong opinion. We're not going to allow that to happen. Okay? This is where it comes up. We talked about it briefly in that other slide where we're building the ladders, but this is the clause that's powerful. And it's really interesting when you bring this up, people are like, whoa, what are you talking about? Once the Supreme Court says what the law is, it is. You can't change that. Well, yeah, actually you can through the Constitution. People, that's nuts. That's crazy talk. You're talking about anarchy. No, I'm talking about the Constitution. If they make a wrong ruling, you don't have to deal with it. You can overturn it, essentially. You can't overturn that ruling in that case, but you can never let them make the wrong decision in the next place. Or you can impeach them and say, you're done judging. You're just wrong. You're off. Okay? That's a powerful idea because then we're not peons. We're not servants. We're not slaves to some big federal government. We are free. We're free, and we can say, no, we don't agree with that opinion. Thanks for your opinion. I'm not going to listen to it anymore. Okay. Article 3, Section 2, Clause 1 and 2. We've hit this before. We're going to hit it a little more in detail now. The judicial power shall extend to all cases in law and equity, and the Supreme Court shall have appellate jurisdiction both as to law and fact. There's 4 words that kind of jump out to me on this page, okay? And I'm maybe going to do a little bit of reading here to make sure I get this right because it can get kind of confusing. I want to make sure I say it correctly. The first word that comes up is law. Very clearly, does the Constitution give the Supreme Court the right to judge our law, the right to judge the Constitution? We like to say no, but yeah, they do. They have the right. It says it right there. Their judicial power shall extend to all cases in law and equity. So they can judge the Constitution. They can interpret the Constitution. And once again, like we've talked about before, there's a consequence to them misinterpreting it. We say we're no longer going to interpret it. We're no longer going to let you have appellate jurisdiction, or we're just going to impeach you, right? Okay? Now, what happens is they're supposed to take the Constitution and use that as their foundation, their guideposts to rule on the laws and the case, the controversies that come before them. The problem is too often the Supreme Court isn't saying, here's what the Constitution says, therefore this law isn't constitutional. What they're saying is, here's what the Constitution says, but here's what I think it should say, and therefore we're going to do this and this and this, and we're going to strike down the law. Does the Supreme Court have the ability to strike down the law? No, all they have the authority to is issue an opinion on the law. Okay, so that's when we get to this idea about law. The next word that comes up is equity. Is the intent of the law being fulfilled? In the case brought before the court, are the individual's rights being abused? Isn't that the whole idea of appeals? I don't agree with your decision, so I'm going to appeal it up. And so that they can rule and say, equity. Is equity being served here? Is justice being served? Okay, so that makes sense. Their jurisdiction, that's part of what they're supposed to do. The next one here is the word fact. Did the events and circumstances occur? Did, in fact, the 90-pound woman shoot and kill a 320-pound man? Yes. Facts are established. The next part here is the law. Once again, we have the law showing up. Does the law apply in this case? Well, the 320-pound man happened to be a midnight intruder who was threatening to kill the woman. So she shot him. So does the law that prohibits human beings from killing each other apply in this case? No. Okay? And if we have precedent, now we have a precedent. We can work on this precedent and say, well, good, now we know that all 90-pound women can kill 320-pound men. Is that true? No, that's laughable. That's not true. It's specifically to the case, the circumstances of that case. Because if we had a precedent now, that would mean all 90-pound women can kill 320-pound men. That's ludicrous. That doesn't make any sense. So you can see how case precedent can get out of control. Because what happens in case precedent? In case precedent, courts and decisions always look back to the case and to the opinion of the court. the lawyer's comments, etc., etc. Instead of looking back to the Constitution, we're a rule of law, we're a republic. We should look back to the Constitution, not back to the previous case. So the Supreme Court can continue to not apply laws in certain cases, and we can know and have that certainty that's what's going to happen. Stare decisis, right? The function of what's happened in the past. But the Supreme Court doesn't have the authority to strike down a law. The only authority that's given to make or repeal laws is given to Congress. Article 1, Section 1, Clause 1, all legislative powers herein granted shall be vested in Congress. Okay, so they're the only ones who do it. So when the Supreme Court issues an opinion and Congress agrees with that opinion, they can do something. They can write a law that says, you know what, we're wrong. We're going to go ahead and write a law that supersedes the previous law and that agrees with the Supreme Court's opinion. But when the Supreme Court issues an opinion that the Congress doesn't agree with, or the people don't agree with, they don't have to just abide by that. They have three constitutional options. The first option is to say, look, we're going to write a law that directly contradicts your opinion. Your opinion's wrong, and we're going to write a law that says that it's wrong. Secondly, they can limit the appellate jurisdiction. You're no longer going to rule on those cases. So effectively, the courts will no longer continue to misinterpret the Constitution. And thirdly, they can, like we've talked about, they can impeach them. Okay, so it's constitutional solutions that deal with an out-of-control Supreme Court. Okay? Now, Alexander Hamilton had an interesting quote. He said, the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution. It may truly be said to have neither force nor will, but merely judgment. Isn't that interesting? All the Supreme Court can do is issue judgments, issue opinions. That coincides with what we've been talking about, doesn't it? They don't have force or will. They can't make things happen. They can't make law. They can't execute law. All they can do is judge and throw out opinions. Thomas Jefferson says, the germ of dissolution of our federal government is in the composition of the federal judiciary, working like gravity by night and day, gaining a little today and a little tomorrow, and advancing its noiseless step like a thief with a field of jurisdiction until all shall be usurped. Now, some people say, now, wait, who's right? Who's wrong there? Hamilton's saying that the Supreme Court won't infringe on any rights. They don't have any power. Thomas Jefferson says, yeah, the Supreme Court, watch. They're gonna advance and become mighty. Who's right? Well, they're both right, because constitutionally, the Supreme Court shouldn't be infringing on our rights, infringing on our laws. Okay? But in reality, what's happened is what Jefferson said. They have this advanced their noiseless step till they've usurped all power. This is one of my favorite quotes. He says, to consider the judges as the ultimate arbiters of all constitutional questions is a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. So if just the Supreme Court, they're the only ones who can decide what the Constitution means, that places us under an oligarchy. What's an oligarchy mean? It means rule of a few. And in this case, how big would our oligarchy be? How few people would run our country? 9, right? The 9 justices of the Supreme Court. But it's better said, it's actually only 5, because all you need is 5 to form a majority opinion. So Jefferson says, you let the Supreme Court just decide and be the ultimate arbiter in all decisions, constitutional decisions, and we'll have an oligarchy. But we're not an oligarchy, we're a republic, we're a rule of law. The people have representatives who make their laws, not an oligarchy of judges who make their laws. Okay. Hamilton goes on to say, the duty of the courts of justice must be to declare all acts contrary to the manifest tenor of the Constitution void. Their job is to take the Constitution and have that guide their decisions in regards to the cases. And what is the manifest tenor of the Constitution? What's the feeling behind the Constitution? What's the Constitution mean? Not just whatever they feel like, but Jefferson makes it very clear. On every question of construction, what does the Constitution mean? Let us carry ourselves back to the time when the Constitution was adopted. Recollect the spirit manifested in the debates, and instead of trying what meaning may be squeezed out of the text or invented against it, conform to the probable one in which it was passed. Okay? So the job of the Supreme Court isn't to create new inventions and to squeeze meaning out of the text. It's to understand the original intent. When the Constitution was made, it was a compact between the states. And those words are written down, those words have meaning. What did it mean? The original intent is what the Constitution means, not the most recent interpretation by a Supreme Court. That's what they're supposed to apply, is the original intent of the Constitution, and not try to squeeze meaning out of the text and create, like they did in Roe versus Wade, create entire statutes out of the Constitution. They aren't even there. They just write them from the Constitution. They can't write statutes. Okay? All right, so now, taking all that time to talk about the judicial branch. Okay? We took a lot of time in our first presentation, Power in the Constitution, to talk about the legislative branch. Now we're going to talk about the executive branch, but it's not going to be nearly as long. Okay? Just a couple slides. Don't worry. Okay. In Article 2, Section 2 and 3, it pretty much summarizes all of the powers of the president. Okay, besides what we talked about earlier in Article 1 where the president can veto, these are the rest of the president's powers. Okay, talking to the executive branch. The president shall be commander-in-chief, grant reprieves and pardons, make treaties, appoint ambassadors, appoint judges of the Supreme Court and all other officers of the United States, fill up all vacancies that may happen during the recess of the Senate, give to Congress information of the state of the Union, and recommend to their consideration such measures that he shall judge necessary and expedient. On extraordinary occasions, convene both houses, receive ambassadors, take care that the laws be faithfully executed. So these are all the presidential powers. And when you look at these, they're kind of administrative powers, aren't they? To receive ambassadors, etc. Those are administrative powers. Why would that be? Well, because he's the chief administrator of the federal government, all the external. Remember, the federal government's in charge of the external affairs, not the internal affairs. So he's more of a figurehead and someone who gets involved that way. And yet today, our president is just a tad bit more involved in our lives than the Constitution calls for, isn't it? Overstepping those bounds. It's really interesting that when a new president is elected, he fills 6,000 federal positions and hires 450 White House employees. 450 White House employees. Hold on a second. Okay, so you look at that and say, it's grown too big. Okay, where's his power to declare war, to make laws because Congress isn't going fast enough, to be a world leader? Those powers aren't there. They're not written in the Constitution. He may have assumed those powers, and the people may have allowed that and condoned that behavior because of apathy and ignorance, but those powers aren't there constitutionally. Okay? Now, James Madison says this, in a representative republic, which we are, the executive magistracy is carefully limited, both in the extent and the duration of its power. Okay? They feared a king. They didn't want a king. They already had enough of a king. They didn't want a king to rule forever. They wanted to have a limitation on the extent of their power and the extent of their reign. Now we're going to talk about in any organization, any group, any system, the greatest power that there is, the power to make laws, isn't it? Okay? So, Article 1, Section 1, Clause 1 addresses the ability to make law. I've already talked about this before. All legislative powers herein granted shall be vested in a Congress of the United States. So, the key word there is the first one, all. This is the very first word after the preamble of the Constitution. All legislative powers is vested in Congress. So how much lawmaking power is left over for the executive branch? 0. How much is left over for the judicial branch? 0. All lawmaking power is vested in Congress. It's important. It's incredibly important to understand that, okay? That they're the ones who make laws. So if making laws is the most important power that there is in any system, in any government, in any organization, the greatest abuse of power would be making laws that you aren't authorized to make, right? So what we're going to do is we're going to discuss modern-day abuses of constitutional law-making power. Nowadays, it's estimated about a third of our laws are made by Congress, a third of our laws are made by the president, and a third of our laws are made by the Supreme Court. Why? We have to look in the mirror because we've allowed it, we've condoned that. But it should be 100% of all laws are made by Congress because they represent us, and they are accountable to us, and we can pick and choose who we like and what they're doing if they're representing us well or not, and put new people in there if they aren't. Okay, so there's 3 different ways to abuse this power. First of all, laws that are made by the executive branch. Secondly, legislating from the bench, right? Laws made by the judicial. And thirdly, Congress making laws, but making laws that are outside of their enumerated powers. We're going to explore each one of these, okay? Each one of the branches of government and how they abuse this lawmaking power. We're going to start out with the executive branch. The executive orders. Everyone hears about executive orders, and everyone gets mad about them because they're so oppressive and they're so wrong. I'm here to tell you, this may frustrate you, but I'm here to tell you, executive orders are definitely constitutional. They are constitutional. Article 2, Section 3, Clause 1 says, the president shall take care that the laws be faithfully executed. How can the president faithfully execute the laws if he has no power to do so? He can issue executive orders. But once again, it's a jurisdiction issue because the executive order doesn't go out to everyone everywhere. The executive order goes to the executive branch. He's the chief executive of the federal government, and he can issue executive orders for the executive department of the federal government to act, to faithfully carry out the laws of the union. Okay? So, an executive order is all right. The problem, obviously, is when the executive order says, oh, this affects our whole nation, or I'm going to write a law. The president can't write a law. He can make an order for his executive department. He can't write a law. Another interesting twist is something called a signing statement. Have you heard a signing statement before? In a signing statement, the president, here's a quote here, the president may express his opinion on the constitutionality of some provisions of a bill, such as those that intrude on his executive power, and declare that those provisions will not be enforced. Now, wait a second. If a bill comes across the president's desk, he has two options. He can either sign it or he can veto it. He can't sign it and cross out a few things and write a signing statement saying, I don't like these ones, but I'm going to go ahead and pass the rest of the bill. That's not within his authority. So you look at these different things that happen, and wait, you can't do that. You can't just make up powers that you think are good. Okay? The second thing in the executive branch is administrative law. Okay? This is what happens in the executive branch as well. Administrative law. Article 2, Section 2, Clause 2, the President shall appoint all other officers of the United States which shall be established by law. Okay? So who establishes these positions? Law. Who's the law? Who makes law? Congress. The President can appoint positions to offices that are created by Congress, but he can't just create positions out of thin air. So what does that say about the czars that we have? They're not constitutional, are they? You can't just create an office. The office has to be created by law, and then you're able to fill that. But Congress is in charge of writing law, and they're the ones who make these offices that can then be filled by the president. Now, it's critical to understand the executive department. Their role isn't to write laws. Their role is to execute the laws that are written by Congress. Now, we talked earlier, James Madison said that in a previous, different quote that we didn't quote, he said, ambition must be made to check ambition. The natural position of the person should be in correlation with the position in the government, right? There should be this natural jealousy to guard my power. So if Congress has the power to make all laws, why is Congress letting administrative law, letting agencies, letting president, why is he letting different people, why is the Congress letting different people make laws? Why are they letting agencies make laws? Why is administrative law so dominant in our world today? Well, this could be a cynical way of looking at it, but what do we hire the congressional leaders, our representatives, to make decisions that are hard decisions, that take a lot of work, a lot of stress. Some people may not like them, etc. So wouldn't it be easier just to say, well, how about we create an agency so that whenever a constituent tells me, I don't like that, I don't like what OSHA's doing, you can say, yeah, neither do I, that bad OSHA group. I don't think they're doing a good job either. And so the heat doesn't come to them, they can deflect it. And what if someone says, I really like what OSHA's doing? They say, I like what OSHA's doing too, they're doing a fine job. And then they never have to make those hard decisions, and they can always pass the buck to the agency. And when we don't like what the agency does, what can we do? Nothing. We can't vote them out of office, can we? What happens when we don't agree with what a representative does? We can vote them out of office. They're accountable to us. So shifting that ability to make law and to make decisions to an agency is actually very destructive of freedom, because it violates this principle of representation, of accountability to your constituency. Kind of interesting. That's why they do it, because they don't have to face the music. Okay? So that's administrative law. Now let's go to legislating from the bench. We're not going to spend a lot of time on this because we've already, I think, kicked a dead horse here with talking about the judicial, Roe versus Wade. Very, very simply, if they make a wrong decision, we don't have to let that happen anymore in the future. There's constitutional remedies to make sure that we don't just allow that to become the supreme law of land, because it's not. Constitution is just an opinion that can be limited. We've already talked about it in detail. And lastly, Congress legislating outside of its enumerated powers. Congress has the ability to make laws, don't they? But they can't make whatever law they want to. They can only make laws that they've been given the express authority to do so, to make laws in regards to that issue. All right? So the perfect example is the Patient Protection and Affordable Care Act, okay? It's commonly known as Obamacare, so I'm going to call it Obamacare, just a shorter name for it. It's a perfect example of how the checks and balances has broken down. So we're going to look at it in more detail. Before we get there, let me show you an interesting slide. Okay, so this picture is worth 1,000 words. It shows us the schematic of Obamacare. Now look at this. We got all these agencies that are created, etc. Now what happened to the states? The states stuck all their eggs in one basket. That basket was the individual mandate. Surely the Supreme Court won't say that there's constitutional authority to make people buy something, make people purchase a product. So 30 states put their eggs in this basket. Yeah, the individual mandate. We're going to put all of our stock in that idea that the Supreme Court won't uphold that. Okay, so if the individual mandate goes away, look at this picture. Ready? There it is. You see it? It disappeared. Oh, there it is. Okay. It's still there, isn't it? Obamacare is still there. And it's interesting to note, with Obamacare, there are 150 new agencies that are created. 150 new agencies. There are still 16,000 new IRS agents. There's still home visits to assess stress management effectiveness in the home visits to assess school readiness, home visits from the federal government to assess family economic self-sufficiency, academic achievement, parenting skills. Okay. In Obamacare, the government still decides who lives and who dies is rationing of care. A lot of people say, well, come on, that won't really happen. It's happening today in many socialist countries. Socialized medicine doesn't work, and so there has to be rationing of care. There's only so many resources, and who's going to decide? Well, the government is. If you're past a certain age, you wait in line, and you die waiting in line. Okay? Section 1553 mandates abortion, euthanasia, assisted suicide. Okay? All these things are there, regardless if you have the individual mandate or not. Obamacare is socialized medicine. It's the first step to socialized medicine. Socialized medicine is tyranny. It's not freedom. Okay? Now, let's get back to how Obamacare really came to us. Okay, we're talking here about Congress legislating outside of its enumerated powers. How did it come to us? It came to us on the silver platter of Interstate Commerce Clause. Okay, Interstate Commerce Clause, Article 1, Section 8, Clause 3 says this: Congress shall have power to regulate commerce among the several states. We talked about this in a previous presentation. We're going to discuss a little bit more here. So, because of the Interstate Commerce Clause, Obamacare came to us. We could talk about a bunch of different quotes, etc. What we can really go to is a simple idea of regulate. It all revolves around the word of regulate, because historically, the states were killing each other over disputes about commerce, the duties and tariffs they're putting on each other. And so the founders said, no, in our Constitution, we're going to give that power to the Congress, make it a congressional authority, so they're able to regulate and make sure commerce continues to be regular and to keep happening, not have it shut down and bogged down because of the disputes between the states. Okay? Article 1, Section 9, Clauses 5 and 6 gets a little more clearly into this. It says, no tax or duty shall be laid on articles exported from any state. And it also says, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. Okay, so Constitution, you can very, very, very clearly see Interstate Commerce Clause is about the shipping. It's about the dock-to-dock stuff. It's about what happens in between the states, the shipping of products. I'm going to give you a little bit of history lesson of how this came to pass, though. It's kind of interesting. In 1935, there's a case called Schechter versus the United States. And in it, the Supreme Court back in 1935 issued a really good opinion. Here's what their opinion was. It says, if the Commerce Clause were construed to reach all enterprise and transactions which could be said to have an indirect effect upon interstate commerce, the federal authority would embrace practically all the activities of the people, and the authority of the state over its domestic concerns would exist only at the sufferance of the federal government. Okay? So they're right on with it. That's a good ruling. It's saying you can't have interstate commerce control everything. Otherwise, the states have to ask the federal government for permission to do whatever they want to do. That's a good ruling. The problem is the summary of that ruling was this: Congress can regulate things that directly affect interstate commerce. And what happens, we had a case precedent. From 1935 on, courts looked to Schechter and said, does this directly affect interstate commerce? So instead of looking back to the Constitution, Article 1, Section 8, Clause 3, and Article 1, Section 9, Clauses 5 and 6, they look back to the case and say, does this directly affect commerce? That's the standard, instead of the Constitution being the standard. Now you fast forward to 1992, you got U.S. versus Lopez. Kind of an interesting case. A young man brought a gun to school in Texas, and there's a Texas state law that says you can't do that. Okay, so he got prosecuted. And then the federal government came along and said, oh, we're going to prosecute you too. And Lopez says, for what? What are you talking about? Well, based on the Interstate Commerce Clause. He said, Interstate Commerce Clause, what? So he took him to court, and they appealed this decision all the way up to the Supreme Court. And in this decision, the U.S. argued, the federal government argued, if kids are in school and they're not sure that someone around them could have a gun, they may feel unsafe, insecure, they probably won't perform as well or learn as well. They may not be able to pass tests as well and gain the skills necessary so that when they graduate, they become an integral and helpful part of our interstate commerce. Okay, believe it or not, that was too much for the Supreme Court. They said, wait, you're piling inference upon inference here. No, even the Supreme Court said, no, you're way off here. And they issued a good ruling. The problem was, once again, the ruling became the precedent. The ruling became the law. The ruling said Congress can regulate economic activity that substantially affects interstate commerce. And so you tell me, does Obamacare substantially affect interstate commerce? You bet. And so now all of a sudden it's constitutional because it's brought to us by the Interstate Commerce Clause. Well, it's not the Interstate Commerce Clause they're quoting, it's the U.S. versus Lopez case that they're quoting. And so you see how case precedent gets in the way. Okay, a perfect example of, hold on a second, they're legislating outside their legislative authority. The judicial branch is upholding it. Chief Justice John Roberts, right? Remember this Obamacare famous decision? He says, simply put, Congress may tax and spend. Can Congress tax and spend? Yeah, but only for specific duties, specific enumerated powers. That's what Jefferson said. Congress has not unlimited powers to provide for the general welfare, but only those specifically enumerated. They can't tax and spend on whatever they want to. They can only tax and spend for those things that are enumerated. Is socializing medicine an enumerated power? No. Congress can't do that then. They can't tax and spend on socializing medicine. It doesn't matter if it's a tax or law, whatever it is, mandate. What matters is Congress can't socialize medicine. Okay? So you have this perfect example, and you say, now wait a second. What then can we, the people, do constitutionally when all three branches of the federal government are ignoring their constitutional duties and are avoiding their constitutional responsibility to check and balance the abusive powers of the other branches? What can we do? Aren't we stuck? We're stuck, right? What can we do? Because all the branches, they're doing whatever they feel like doing. No one's checking each other. It's completely out of control. And you see how we wonder, wait, what can we do? I think we just get mad. That's all we can do. But you realize it's because we're stuck in this paradigm, the idea that checks and balances only happens at the federal level. Because at the federal level isn't working. What are the federal checks and balances aren't occurring? Well, we need to talk about the division of powers now, don't we? Some people say what we need to do is put pressure on Congress to repeal or defund Obamacare. We've already done that, right? We've already put that pressure. How did that work out? Did we repeal or defund Obamacare? No. What about, let's trust the Supreme Court to overturn it. We've already seen that didn't work out. They consider it to be constitutional because it's a tax or whatever they want to reason there. Or, hey, what we need to do is elect a new president or a new Congress from a different party. That'll fix it. Well, that won't fix it, will it? Because both parties are supporting their own version of socialized medicine, whether it be Obamacare or the new Republican version of socialized medicine. So if you put your trust and your stock in the federal government, you're going to be highly disappointed because those things aren't working out how they need to. But that's not the only check and balance that we have. The most powerful check and balance that we have is, we're going to talk about here. Jefferson puts it this way, okay? He says, the several states composing the United States of America are not united on the principle of unlimited submission to their general government. It's like we talked about at the very beginning of the presentation. They're not united to say, oh, we'll just do whatever you tell us to do. That's not why they came together. He said, but under the Constitution for the United States, they constituted a general government for special purposes and delegated to that government certain definite powers. They got together and said, we're going to have a central government and tell them certain things they could do, and that's it. This federal government was not made the exclusive or final judge of the extent of the powers delegated to itself, since that would have made its discretion and not the Constitution the measure of its powers. That's a really interesting concept, because wait a second, it's a contract, it's a compact between the states, and they form the Constitution, they form the federal government. The states, the federated states, form the federal government. So why would all of a sudden the federal government be the one to choose when they are acting properly or improperly? Whoa, that doesn't make any sense. Because then the creature becomes greater than the creator and tells the creator what to do. You can see how upside down we are if we think the federal government is our master. They're not. They're our servant. We created them. They don't tell us what to do. We tell them what to do. Okay, so that's what he's saying in this quote. Whensoever the general government assumes undelegated powers, a nullification of the act is the rightful remedy. Okay, nullification isn't sedition. It isn't secession. It's not anarchy. It's not treason. It's not picking and choosing which laws we'll obey. Nullification is a constitutional remedy. It's a 10th Amendment remedy to say, look, we gave you certain powers. We never gave you that power. If you choose to use that power and exercise that power that we never gave you, we will ignore that in our state. We're not gonna do whatever you tell us to do. We only gave you certain powers. When you act outside of that, nullify it. We're not gonna honor that unconstitutional law in our state because we don't consider the federal government to be supreme. We consider the Constitution to be supreme, and it clearly states if that power is not given to you, it's not yours. Okay? Madison makes another excellent point. He says, in case of a deliberate, palpable, and dangerous exercise of other powers not granted by the Constitution, the states have the right and are in duty bound to interpose for arresting the progress of the evil. It's interesting. What he's saying is your state legislators, when they take an oath of office, they take an oath to the U.S. Constitution and to the state constitution. Why would they take an oath to the U.S. Constitution? Because they're in duty bound to interpose themselves, like he says in this quote. If the federal government tries to come and usurp and tyrannize our state, they're in duty bound to interpose, to stand between the federal government and us and protect our rights. That's their duty. It's their duty to nullify unconstitutional laws. Okay? Everyone's scared of nullification. It's a very simple concept. It's not a crazy concept. It's a constitutional concept. It's a concept that says the Constitution reigns supreme and not the federal government. Okay? Now, Madison and Jefferson are well known for being conservative, the people's people. Okay, even back in the day, amongst the founders, there was more conservative leaning, more progressive leaning. They're on the conservative end. We're all about people. We're all about small government. There's some other central government type people. The most famous one was Alexander Hamilton, very much a central government type of guy. That's where he kind of leaned that way. So it'd only be fair to see what was his opinion on this idea of nullification, this idea of, the states standing up for their rights. Well, let's see what he says. He says, if the states enter into a larger political society, like the United States, the laws which the United States may enact that are pursuant to the powers entrusted to it by its Constitution must necessarily be supreme over those states and the individuals of whom they are composed. That's simply restating the Supremacy Clause, isn't it? If we give them powers and they exercise those powers that are pursuant to the powers that are given, they are supreme over the states and the people. But he continues and says, it will not follow from this doctrine that acts of the United States which are not pursuant to its constitutional powers will become the supreme law of the land. These will be merely acts of usurpation and will deserve to be treated as such. So even our more progressive Alexander Hamilton says, whoa. Federal government can't just do whatever they want to do. If they do something that wasn't given them the power to do, then it's completely in the jurisdiction and rights and authority of the states to say, no, we nullify that. We don't honor that. Okay, so let me give you one quick example of how nullification works, what a nullification bill looks like. In 2011, in Wyoming, there was a nullification bill to nullify Obamacare. Since we talked about Obamacare quite a bit here, we'll show you one example. This obviously isn't the meat of the bill. These are kind of just little highlights, but it points out what nullification is all about. Okay, so Federal Healthcare Nullification Act. First of all, Section 1 says the legislature of the state of Wyoming finds that A, the people through the states created the federal government and gave them certain enumerated powers. That makes sense. Letter B, the 9th and 10th Amendments define in whose hands the powers that are not specifically enumerated remain. Letter C, the assumption of power by the federal government into healthcare itself, not the individual mandate, not the different parts of Obamacare, but the federal government's intrusion into healthcare interferes with the rights of the people of Wyoming to regulate healthcare as they see fit. It's an intrusion on our right to self-govern. It's our issue to deal with. It's not the federal government's issue to deal with. Section 2 is the new law, in which it states the legislature of Wyoming declares Obamacare null and void and of no effect in this state. And letter B is kind of the kicker, the one that has teeth. Any official attempting to enforce an act, law, or rule in violation of this act will be guilty of a felony. If you come into our state and try to impose a federal law that's unconstitutional, you will be guilty of a felony. If you're inside of our state, if you're a state employee and try to implement a law that imposes this unconstitutional Obamacare, you will be guilty of a felony and be treated as such because it's violating the Constitution. And we in Wyoming uphold the Constitution. We will not allow this to happen. Now, did this Nullification Act make it through? Unfortunately, no. There are too many people who were scared of nullification, said, oh, well, we can't do that. That's crazy. We can't just pick and choose. In fact, there's a prominent leader in our state who said, we can't just pick and choose which laws we're going to follow. Actually, we can, and we will. We will pick and choose. We will choose to follow only constitutional laws, and we will choose to not follow any unconstitutional laws. And we're not just going to do it haphazardly. We're going to create an actual nullification bill that states that and puts us on the grounds that the Constitution is the supreme law of the land. So there you have it. Checks and balances in the Constitution. When you start to really look at it, really kind of interesting. And we realize we've got some challenges, but the challenge isn't the Constitution. It's not up to the task. The challenge is the people who don't understand the Constitution, the power of what's in the checks and balances that offers us freedom. Freedom is a great thing, and it's there. It's just ours to grab and ours to go after. And when we understand those checks and balances and put them in a proper working order, that's what we get. We get freedom through our Constitution.